Happy Thursday and welcome to our webinar reboot, case law update on offering post-petition payment terms to your clients. The topic is bifurcation today. I'm Dan Garrison from Fresh Start Funding.
And I'm Matt Hartley, also from Fresh Start Funding.
So a couple housekeeping items before we jump into the substance. Many of you have probably participated in our webinars before and know the drill here, but we're using Zoom. There is a toolbar at the bottom of your screen that'll allow you to ask questions and queue those up for us. We're going to handle questions at the end of the presentation. This one's going to be a little bit longer than our typical webinar. We're probably going to go 40, 45 minutes and then allow 10, 15 minutes for a Q&A session at the end. So when a question pops into your head, feel free to type it in to the Q&A box at the bottom. And as I said, we'll deal with those at the end. Our agenda today is pretty simple. We're going to give you an overview of bifurcation just so that we're all on the same page about the topic that we're talking about. We're going to talk a little bit about the history of the practice because talking about current developments and current case law really is less meaningful if you don't know the history of things. And then we really are going to do a deeper dive on what's been going on over the last 12 months in this space and some notable decisions and some pending matters of interest that I think all of you will find interesting.
Yeah.
So let's kick off by talking about what bifurcation is. Matt, you want to walk through the nuts and bolts?
Sure. I mean, bifurcation is merely splitting the work an attorney does for a client into pre-petition work and post-petition work. And when done correctly, it's done with two fee agreements with the client, one that's signed pre-petition for the pre-petition work, and a second one that's signed post-petition for the post-petition work. And the whole idea behind it is it allows attorneys to collect fees post-petition pursuant to that post-petition fee agreement. With regards to the pre-petition agreement, the attorney needs to either collect fees for that work being performed pre-petition, or like a lot of attorneys, if they're doing a zero down, you literally waive any fees you would have otherwise earned for that pre-petition work. And it just a key nuance of that is to make sure that the work you're being paid for post-petition is solely for that post-petition work and has nothing to do with any pre-petition work you did.
Actually, let's pause for just a second. We've gotten a couple comments that we've got a significant echo in the presentation. Our producer, Joni, is at the other end of this thing. Joni, could you check and see if the microphone on the laptop that you're using is active? Because it may be picking up sound on your side of things.
On the other side.
All right, it looks like some folks are having the issue and some aren't, so it may be an issue on the other end of the computer here. So we're going to go ahead and keep plowing forward and see if we can fix this for those that are experiencing a problem. So Matt, you were talking about the why behind it, the purpose of bifurcating.
And so the challenge in Chapter 7, as we all know all too well, is that the code wasn't originally established, or at least maybe even interpreted in a way that made it easy for people to pay an attorney for Chapter 7 services. And so the way it's been done traditionally is that the attorneys would collect all the fees up front. Otherwise, they would be a creditor in their own case that they're filing for their client. But even that was a little bit of a fallacy because attorneys were being paid up front for work they have not even done yet. But it became the accepted way of doing things. And so bifurcation really came about, and the reason for it is to allow more people to have access to having an attorney file a case for them, allows them to get their cases filed sooner, and it gives the attorneys a way to get paid for the work.
Yeah, so the problem that exists out there is one that I think we're probably all familiar with, and that is that debtors are languishing longer than ever outside of bankruptcy. There have been a number of studies that have been published in the last year or two, including a significant one by the Consumer Bankruptcy Project, which, as many of you may know, is a think tank essentially of professors and jurists and notable scholars in bankruptcy, kind of looking at how the system's working for everyone. And they published their findings just this last year of their most recent study and concluded that, in a nutshell, people are suffering more than they ever have before for a number of reasons. But the average debtor is spending at least a couple of years in financial distress outside of bankruptcy. And they've noted effects on families, on the availability of healthcare, food and necessities, and so forth. Mm-hmm. But the real dilemma is that attorneys don't like taking the risk of trying to collect voluntary payments post-petition. And as Matt noted, the code doesn't really deal well with this. We're all afraid of the stay and the discharge. And so what that leads is to a number of kind of ad hoc solutions other than bifurcation that don't work very well. We all have been at court, on reaffirmation calendars and seen how pro se debtors struggle with the system. They are absolutely a burden on the judiciary and the clerk's office. And to their vast credit, the judges typically do hold these folks' hands quite a bit more and try and shepherd them through the process, but it results in hearings being continued and a lot more time being taken on relatively simple things that if the debtor had an attorney would be much easier.
Yeah, a lot of the cases just get dismissed.
Yep.
They just don't know how to complete the case when they're trying to do it on their own.
So it turns out, across the nation, the statistics suggest that a represented Chapter 7 debtor obtains a discharge almost 100% of the time. It's in the 99 plus percentile. But in stark contrast, pro se debtors only get a discharge about 70% of the time across the country. So there's a 30% decrease in success in bankruptcy as a result of not having an attorney. So clearly, the system works better for attorneys and it works better for the judiciary and the court system itself if folks are represented. And that has led attorneys to try and implement solutions to the problem that don't work well. So for example, a very common tactic is to offer to accept payments from a debtor, but they have to pay the full fee before the case is filed. We call these layaway plans, for those of you who are old enough to remember putting Christmas presents on layaway at JCPenney or Sears. It's a callback to that. And Matt and I both in our practices, instances where folks would make payments anywhere from several months to sometimes a couple of years before they get the fee paid and get what they were really looking for, which was that relief of the automatic stay and ultimately the discharge.
And you always get the ghost cases too. So that people would pay something and then stop paying and they would disappear. So then you'd be holding funds you had to deal with. They would show up again, maybe a couple of years, ask for a refund. I mean, administratively, it creates a lot of nightmares for attorneys too. But it really is the biggest problem is delaying when these debtors are getting their cases filed and they're continuing to suffer.
Well, and it really puts attorneys and debtors kind of at odds in conflict with each other because the one thing that they're looking for from you is that fresh start and that relief. And for understandable reasons, at least before bifurcation became a viable solution, attorneys would have to put their interest in collecting their fees ahead of the debtor's interest in getting that relief. So the other workaround that has become kind of prevalent in some districts, which presents all kinds of problems in our view, is what are referred to as fee-only Chapter 13. So these are debtors that could otherwise qualify for a 7. It would be in their best interest to file a 7. But since they need immediate relief and the attorney needs to have a way to get paid, they'll file a Chapter 13 case for the debtor instead of a 7 for the sole purpose of making the fees an administrative claim of the bankruptcy estate, knowing that the debtor is only going to be able to generate enough excess income during the plan term to basically pay the attorney's fees, the administrative expenses of the bankruptcy case. Yep. And creditors receive nothing in these scenarios.
Yeah, and oftentimes the debtors still never get the discharge because they can't keep making the payments for 3 to 5 years.
Yeah, the statistics vary across the country, but it's a similar kind of a problem to pro se Chapter 7s. In Chapter 13s, somewhere around a third of debtors who enter Chapter 13 actually emerge with a fully performed plan and getting their discharge. And in most districts, it costs more. Even if the attorney is willing to do a relatively low budget Chapter 13, it's still much more expensive than a Chapter 7 would be in the first place. And so we think fee-only Chapter 13s present a lot of ethical challenges. And in fact, a number of judges around the country have commented about, how troubling they find the practice of putting debtors into 13s when they could and should otherwise be in Chapter 7s.
Yeah.
So, Matt, you kind of touched on what bifurcation is, but maybe we ought to get a little bit more into the weeds about how it's done.
Yeah. So as I mentioned earlier, bifurcation is splitting the work into pre-petition, post-petition work. You have pre-petition fee agreement and a post-petition fee agreement. But let's talk about how that really works in the normal practice. So when a client comes into your office, meets with you, typically they would sign that fee agreement at the initial consultation. After you do full disclosures and if your client about the bifurcation and give them the options of either paying up front or doing a bifurcated case. But assuming they selected the bifurcated case and it works best for them, then you do your typical due diligence that you have to do in any case. So you're going to still have them bring your documents, their tax returns or bank statements, et cetera. You're going to pull their credit report. You make sure they haven't filed a case recently, and if so, figure out how to deal with that. You just do all your basic work you would do in any case before you file it. But what you do though is you file just a skeleton or sometimes called a rush case just to get the case started. So you file just the minimalist documents that need to be filed. The code is clear on what needs to be filed. codes also very clearly have 14 days to file the rest of the documents. And the rest of the documents are obviously the statements and schedules. But anyway, after the case is filed, in some cases the same day, in some cases 2 weeks later, the debtor comes back to review the statements and schedules that were prepared post-petition. They sign a post-petition fee agreement for you to continue in the case and agree to make payments to the attorney. And then once the client has reviewed and signed all the statements and schedules, you file them and proceed with the case in the normal manner.
Yeah, I think it bears repeating that, it's important if you're pushing work into the post-petition engagement, which obviously makes this more economically feasible for attorneys, that not doing the schedules and statements before the bankruptcy case is filed does not in any way relieve you from doing an appropriate amount of diligence, to sign off on that petition as counsel.
Yeah.
And those things really can be summarized in 3 buckets. It's, do they qualify? Is it in their best interest? And are there landmines lurking beneath the surface in this case that you'd be better off discovering now than having blow up after the case is filed?
Yeah.
And, we talk to attorneys all the time about the concern that they typically do that diligence in a prepaid case by filing and preparing and filing the statements and schedules. But there's nothing that requires you to use the process of preparing the schedules and statements to accomplish that diligence. And so folks instead are using robust intake questionnaires, a very robust consultation process where you're really asking all the questions and getting answers. And then, as Matt said, gathering the documents, doing the credit download and so forth, so that, you get as complete a picture as possible.
Yeah, and if any of you on this don't have a good intake, we have one, we have a sample we're happy to share with you.
So, the question that often gets asked too, besides the how, is the why. Why do attorneys want to engage in this practice? And really, it's a 2-sided equation, that is summarized best by the old adage of doing well by doing good. This is a way for attorneys to build their practices by helping those folks that couldn't otherwise engage an attorney, and help the system and help debtors by providing, that professional assistance that'll help them get through the process successfully.
Yeah, one interesting statistic that we hear consistently, and I guess I should point out, we have over 300 law firms have signed up with us. We're operating in 43 states now. It'll soon be all 50 states. But we hear the same stories over and over from attorneys on certain topics. And one of them is, how are those initial consultations going? And what happens for most attorneys is about half of the clients that come in, or potential clients that come in, don't retain the attorney. And they don't do it because they don't have the money. And sometimes they say they're not doing it because they don't have the money. And sometimes they give I got to think about it or whatever. But at the end of the day, it's all about, they just realize they don't have the ability to pay. And it's just the classic thing. You have consultation, your client tells you about what's going on in their life, and you figure out bankruptcy is best, and you as attorney say, no problem, I can make this all go away by filing a Chapter 7 case for you. Just give me, X dollars, $2,000 or whatever it is, and I will, I'll make it all go away. And then you get the blank look on the potential client's face who says, I just told you I'm bankrupt. I don't have any money. Yeah. And so the why of this is that for those people, there's now an option. You can, as an attorney, you can have those people still retain you. You can get their cases filed right away, get them the benefits of the automatic stay, and then they can make payments after the case has been filed.
Yeah, what we see as a result of that pretty typically is that rate of engagement and consultation goes up from 50% to something more like 75 or 80% or even higher. The other thing that we see pretty consistently is that folks who are using particularly paid marketing approaches like pay-per-click, Google AdWords, that sort of thing, is that they're generating a whole lot more activity for the same marketing dollar. And so from the top stage of the funnel, where you're trying to get folks to fill out a form or make a phone call, your numbers improve there, more people show up for the consultation, yeah. More of them engage, and for all the right reasons, because you're providing a solution to them that they otherwise wouldn't have available, and they can get what they need the most, which is that relief, and they can get on to a fresh start in their lives immediately. And then make payments over time. And we'll talk a little bit more about the services that we provide to kind of facilitate that at the end of the presentation today, because there are some other benefits like credit reporting and the ability to, start rebuilding their lives from that perspective too.
So let's jump into really the history of this and,
sure.
and the case law and the like on this.
No, so I'm going to hazard a guess that a lot of you feel like you've heard about bifurcation for the first time fairly recently, but there's actually a long history of the practice of offering debtors post-petition payment terms and a lot of false starts at ways to do this that ultimately didn't work out. And it goes back about 25 years to the mid 90s. And there were a number of cases in Arizona and California where some creative firms tried to offer debtors post-petition payment terms under a traditional single engagement agreement that was signed before the bankruptcy was filed. And in 4 out of the 5 of those cases, the courts concluded that collecting the post-petition payments violated the stay and ultimately violated the discharge injunction. There was one case in Arizona going back to 1995 that approved the practice of collecting the payments. But the difficulty was that you were operating under a contract that was entered into before the petition was filed. And so under normal principles of bankruptcy, it was pretty easy for the courts to conclude that that contract was stayed from enforcement and ultimately discharged. Things started to change in the late 90s, and there was a seminal decision that came out of the Ninth Circuit in 1999 called Hines. And what the Hines court found was that although the contract was discharged and the stay applied to it, because the attorney was doing a portion of the work post-petition, that there was an equitable right to be paid for that work under the doctrine of quantum meruit, or unjust enrichment is another term that gets referred to a lot. And so it allowed the attorney to collect the reasonable value of the post-petition services that were rendered. Now, I can tell you a number of subsequent decisions criticized the Hines decision, even though it was a circuit-level decision from the Ninth Circuit, about the way in which it went about the analysis. But Hines still stands for the proposition very strongly across the country that you really don't earn the fees until you do the work. And so it represents a very foundational piece in what ultimately has become the practice of bifurcating engagements. Mm-hmm. So from and after 1999, there were a number of decisions throughout the 2000s, one notably called Bethia in the Seventh Circuit, that invalidated the post-petition collection of fees for a pre-petition agreement, but in dicta noted that there was a solution, apparently, and that was that a debtor could tender a small amount of money up front to get their case filed, and then could engage the attorney to complete the case under a separate agreement. And so while the attorney lost that case, the Seventh Circuit Court of Appeals really suggested a pathway through that looks very much like what we now consider the modern practice of bifurcation.
Yeah.
So, it's probably a good idea to pause at this point as we're talking about the case law and just kind of look at this from a practical perspective. And really what we're talking about doing here is not that different from things that happen in bankruptcy cases all the time. So, for instance, all of us have probably had situations where a debtor's filed a pro se petition and realized pretty quickly that they were over their head. And I don't think any of us would dispute the legal idea, at least, that pro se debtor could hire an attorney to complete the case after they'd filed their petition, could sign a post-petition engagement agreement, pay the fees out of post-petition earnings, and that wouldn't be a problem. And it's also true that debtors sometimes hire a different attorney to complete the case. Sometimes it's because of circumstances beyond anyone's control. Attorneys retire or they die and become incapacitated, and the debtor has to find someone else to finish the case. And clearly there's a pre-petition arrangement and a post-petition arrangement in that circumstance. And certainly nobody disputes the idea that debtors can hire and fire counsel as they see fit and can really fashion engagements the way that they would like to, subject to rules about limited scope representation and things that we'll talk about in a few minutes. So with that kind of interlude about the practicalities of the situation, let's talk a little bit more about what happened in the case law after 2003 or so. So for a period of about 8 years, there was a lot of experimentation going on. On the heels of the Hines and Bethia decisions, people tried to figure out ways to offer post-petition payment terms. A court in Illinois, Northern District of Illinois, in a case called Griffin, suggested the same two-contract method. A number of cases in Pennsylvania and Tennessee involved what we call straddle agreements, where there was a single pre-petition agreement that separately called out the pre- and post-petition services and allocated the fee between them. And those have occasionally been approved, although I think they're widely kind of criticized now. And all that experimentation basically culminated in 2012 in 2 decisions being issued. One in the Middle District of Florida in a case called Walton, and one in the Eastern District of Michigan in a case called Slobbing. And in both of those cases, an attorney bifurcated the engagement in exactly the way we're talking about here. And ultimately, the courts in both of those decisions approved the arrangement, really without any reservation. There are stories behind both of those cases that I think are interesting. So in Detroit, where the Slobbing case was decided, there were actually 5 cases pending that had tried different methods of bifurcating or offering post-petition payment terms. And Slobbing was the one decision out of the 5 that ultimately concluded this is the right way. I will tell you too that the Slobbing decision really remains one of the very best decisions out there in terms of how it explained the ethical rules and the bankruptcy code and kind of ticking off the boxes about how you do this correctly. And so I definitely would commend it to those of you who want to do a little bit of extra reading on the topic. The Walton case is interesting too because it involved a big firm in the southeastern United States called Clark and Washington. Many of you here today may be familiar with that firm, very high volume firm. And they had had multiple run-ins with the U.S. Trustee's office and had gotten shut down in different ways of offering post-petition payment terms through post-dated checks and things like that through a sequence of decisions. And the 2012 Walton decision represents them finally figuring out how to do it in a way that would be approved. They still got challenged by the U.S. trustee, but at that point the court said, look, we've had multiple stages of this discussion and they've changed their practice each time. And they finally found a way to do this that is consistent with the code and consistent with the ethical rules. And so the court approved it over the U.S. trustee's objection. And, you know, those 2 cases really kind of laid out the roadmap that has been in place since that time. And, you know, for the ensuing years between 2012 and 2019, really, so for about 7 years, there was, you know, continued experimentation with how to do this correctly. And so there have been a lot of decisions that have been discussed over the years, the Grimm decision out of Idaho, the Wright decision out of Oklahoma, a number of challenges of attorneys who were working with an outside company that offered some factoring services around this, where attorneys just didn't execute properly. They didn't either technically bifurcate the engagement into 2 distinct agreements, or they failed to get informed consent from clients. They failed to make proper disclosures to the court, and I can tell you that that was the one consistent factor in every single one of the cases. Or they were perceived as charging an unreasonable fee and got in trouble under 329.
Yeah, but one of the important things to note in like N. Ray Grimmett and in the Wright case, sometimes people cite those cases as, well, see, you can't bifurcate. There's cases, they say it's not allowed, but that's not at all what the cases say. They don't even deal with bifurcation. They just deal with all the mistakes the attorneys made. N. Ray Grimmett in particular, I mean, it was pretty shocking, some of the things the attorney did. So again, those are all good cases. They don't say you cannot.
Well, you know, and it's interesting. Matt's right. I mean, there is a lot of common misunderstanding about those cases. Grimmett in particular gets talked about as an anti-bifurcation case, but Judge Pappas in the District of Idaho, who authored that decision, went out of his way to say clearly, I am not rendering any sort of decision about bifurcation. This is about a lack of disclosure. It's about an unreasonable fee. All the typical things that we talk about with attorneys every day, the pitfalls that you need to avoid in this practice.
And the attorney telling his client that if he didn't pay, he would get their discharge revoked.
Yeah.
So.
Yeah, you can imagine what precipitated the Grimmett dispute was that the attorney sent a dunning letter to the client basically saying, if you don't pay, I'm withdrawing, you won't get your discharge, so on and so forth. And that letter made its way to the judge. And the judge was not amused by that in any way. And that's really what prompted the dispute that generated the Grimmett decision. But yeah, Matt's right. These cases that ensued between 2012 and 2018, there is a very clear pattern to them that can be summarized in some easy to articulate pitfalls. One is that you've got to have robust disclosures to your client and get their informed consent. And that's particularly easy to do if you offer options, offer a prepaid option, offer a pay over time option, and they're clear about the choice that they're making. The second thing is making proper disclosures to the court. We've authored a couple of published articles in the ABI Journal, the second of which this last July talked about disclosure at length, and we've got very robust disclosures that we provide to our clients to help them tick off that box. And then the final one is reasonability of fees. You still are absolutely subject to Section 329 and Rule 2017B. And we've got a 2016B or B2030 disclosure that we provide to attorneys that helps you out both with the reasonability and the disclosure questions there. So more about that to come. So now we're fast forwarding to 2019. And as many of you may have heard, there was a decision that was issued out of the District of Utah.
Yep.
in a case called Hazlett, and it came out in April of last year. And there, again, an interesting story that we'll spend a little bit of time on. There was a debtor, prospective debtor, who went to see one attorney who only offered a prepaid option for, I think it was $1,200 for the Chapter 7 case. And that debtor couldn't see how they would pay that fee, so they went to attorney number 2, who offered a pay over time option, a bifurcated engagement, at a quite a bit higher fee. The fee was about $2,100, I think, as an alternative. And not surprisingly, the client hired the second attorney, got relief immediately, got through their case successfully. And first attorney was a little chapped about that. And so basically whispered in the U.S. trustee's ear that the second attorney's practices needed to be looked into. And that generated this dispute that culminated in the Haslett decision. And really, it was an out-and-out challenge to bifurcation. Is bifurcation legal? And then all the subsidiary questions about disclosure and reasonability of fees and so forth were addressed as well.
Yeah, and a lot of the issue actually came from the first attorney who convinced that debtor that they shouldn't have to make any of those payments. And so that debtor then retained the first attorney to go fight the second attorney about the fee.
Yeah.
And so it was a big, ugly mess. I think a lot of emotions were involved in that one.
Yeah, and I can tell you, I spoke on a panel to the Idaho State Bar this last year before the Haslett decision was issued, and my co-panelist was the first attorney that was involved in the Haslett decision. And she was convinced that they were going to win that case. And the punchline that we're talking about today is that obviously that didn't play out the way she expected to. But she really, was on a bit of a crusade, I think, to try and shut down bifurcation, particularly in her district. But she's also spoken nationally at the NACBA conference, and I spoke with her in Idaho. She hasn't really spoken since then, but
the big picture, I mean, the beauty of Hazlett is it's a really well thought out, well written opinion. It really dives into all the issues that the trustees have raised over the years about the issues they have or concerns they have with bifurcating and collecting fees post-petition. And the judge dealt with every one of the issues, and of course, as most of you know, ruled in favor of the attorney and found it all to be acceptable.
So breaking that down a little bit, I can tell you sort of the classic challenges that have continued to come up that all came up in Hazlett too. So there was an issue of informed consent and whether or not splitting the engagement was something that the client understood and chose freely. And the court went through that analysis and concluded that in fact there was informed consent. The court looked at actually looked at the ethical rules in Utah. There wasn't a local limited scope representation or unbundling rule, but the analysis actually paralleled that. Where the concern is, if you have a local rule that says that once you file a case, you're stuck with it, and there's a certain, list of services that you're obligated to provide, does bifurcation violate those rules? And it doesn't. Judge Anderson in Utah broke that down and said those rules are designed to promote a person having an attorney throughout the bankruptcy process, and bifurcation in fact serves those same purposes because the intent is not to limit the engagement. In fact, it's very clear from the outset that the client wants to hire the attorney to represent them for the whole case. The attorney simply offering a structural option to the engagement that allows that client to make post-petition payments, and in the process offers them representation that they might not otherwise be able to get because they don't have the money to pay up front. And Judge Anderson really did another deep dive on the sweatbox kind of dynamic that exists where a lot of debtors just don't have a choice. They can't readily come up with the money to pay.
Mm-hmm. One of the other issues that he went into as well was the reasonability of the fees. And it was really great, honestly, that he went into, he looked at it the correct way by using the Lodestar Analysis, which takes, looks at a reasonable hourly rate, and you multiply it by how much time you spend, and that's how you kind of come up with a basis of a reasonable fee. Some of the trustees have argued that, well, your fee was $1,000 and now it's $1,500 if you are bifurcating, and so that's unreasonable to raise your fee. But it has nothing to do, the reasonableness of the fees have nothing to do with what you charged before. It has to do solely with your hourly rate and how much time you allocate to the work that you did for the client.
Yeah, and this Lodestar, for those of us who practiced a bit, my practice for 20 years was in commercial bankruptcy, primarily in Chapter 11. The Lodestar method is well known. It's the way that fee applications are analyzed, but it's even broader than that. The Lodestar Approach is the standard for assessing reasonability of fees across the federal court system. There is no disagreement among the circuits or among different types of cases. It's used for fee shifting provisions. It's used for fee applications in commercial bankruptcy cases. And what the Hazlett decision makes clear, and correctly so, is that it's also the method for assessing reasonability under 329 for a flat fee in a Chapter 7 case.
Yep.
So it's interesting. Hazlett generated a lot of discussion nationally very quickly. I mean, Bill Rochelle, who does the daily case law blurbs for the American Bankruptcy Institute, actually featured it on one of his video releases in April after the decision was released, and generated a lot of panel discussions across the country, including many that we were involved with. And ultimately, in August of this year, and this is very interesting. Last year, yeah, 2019. I'm a little bit behind here. Clifford White, who's the director of the U.S. Trustee Program out of D.C., was speaking to the National Association of Bankruptcy Trustees in their annual conference in Denver. And he gave a long speech on a number of topics, but he spent several minutes talking about the Hazlett decision. And that speech is actually published on the Department of Justice website. Mm-hmm. And what he said was that while they've successfully challenged, in other cases, different bifurcation practices involving unreasonable fees and lack of disclosure, they lost the Hazlett decision. And he said, notwithstanding sort of the sting of losing the decision, that he had to commend the decision for its thoughtful analysis, and that really it highlighted the factors that they look at when the U.S. Trustee Program decides to challenge an attorney who's employing a bifurcated engagement. And he talked about those same ethical pitfalls that we summarized a few minutes ago, and said basically this is the roadmap that he commended to the U.S. Trustee Program and to the bar to understand how to bifurcate correctly.
Yeah, and it really was a big deal, because even with all the cases that have come up around the country, there are still attorneys who were concerned that, well, it hasn't been a case in my district or my circuit, so I just don't know if this is going to be allowed. But now that the head UST came out, as Dan said, in August of 2019, and commended the analysis and commended attorneys to follow that analysis in Hazlett. I don't know if endorsement's the right word, but they've made it clear what they what they're concerned with, and that there's no issue with bifurcating. It's just you have to do it right.
Yeah. So to that point, I don't want this to be a question of are we characterizing or spinning this a certain way. Let me just give you Cliff White's words from his speech. He said, "In the District of Utah, the bankruptcy court handed down a decision in re Hazlett," and he gives the citation. "I commend that opinion to your attention." Because the careful reasoning of the court actually highlights the factors we look for and which are almost always absent in the cases we bring. And he went on to say in a later portion of the speech, "The court's opinion provides an important four-part analysis in assessing bifurcation practices. It is instructive to the USTP and should be instructive to the bar as well." Those are his actual words. So don't want there to be any confusion about what Cliff White told the National Association of Bankruptcy Trustees. I can tell you, though, as well, Matt mentioned we work with over 300 firms across the country, and I have pretty regular discussions with folks in U.S. trustees' offices across the country, and they seem to have very much kind of fallen in line to this approach of it's not a question of whether you can bifurcate, it's a question of how you bifurcate. Mm-hmm. And they seem to be following the Hazlett decision in terms of looking at those factors that Judge Anderson analyzed in that decision. So Hazlett really, even though it doesn't represent a different conclusion than Walton and Slobbing reached in 2012, it has really kind of been a watershed event in the case law around bifurcation and just in the last 12 months. Yeah. There are some even more recent developments that we want to talk about.
Yeah, and so just, I guess, would have been last week.
The 22nd,
a judge in Kentucky actually went through the similar situation like in Hazlett. The one difference in this, and we'll talk about this a little more later, is that it wasn't actually the U.S. Trustee's Office that raised the issue. It was a panel trustee. Which raises all kinds of interesting legal questions. But the U.S. trustee didn't even have an issue with it, but it nonetheless proceeded under the panel trustees' objections. And so this judge as well, did a very thorough analysis of all the issues with bifurcation and blessed it as well. It's a great opinion. Went into the ethical rules as well, and talked about the unbundling issue and the reasonableness of fees and everything. And it was a really well written, well thought out opinion again.
Yeah, this case is called In Re Chandra Carr. It was issued by the bankruptcy court in the Eastern District of Kentucky, and we will have a copy of that decision on our website that you'll be able to access if you can't find it easily another way.
Yeah, one of the other interesting things, a point of pride, I suppose, is they actually cited one of our ABI articles in one of the footnotes of the case. So we do feel we've had a role in the shaping of the case law across the country on this.
Yes.
But again, just another great case, right on point, and I blessed it once again.
Yeah, it's interesting too. The one criticism that the judge made was that from her perspective, the B2030 or Rule 2016 B disclosure did not disclose clearly the two contract structure. I spoke to the attorney involved in that case at length yesterday, who actually has signed up with us, and he's not, we didn't get involved in the litigation in this case. He handled it himself, but he says that his disclosure actually did contain the two contract reference, but his attitude, like ours, was, great, Judge, I will do that going forward. And there wasn't any sort of penalty or sanction associated with that. The court just in an offhand way said, the one criticism I have is that you should probably do a better job with disclosure. And
yeah,
we preach that every day. So
yeah, and again, he just had to do it in future cases. No foul on this one.
So that Carr decision really represents a continuation of what started with Walton and Slobbing, continued through Hazlett, and now, you know, the Eastern District of Kentucky has followed suit. That's certainly not the only case around the country that we want to talk about, though. We're actually involved in a dispute in Virginia right now. Matt kind of alluded to this, that there's a panel trustee in Virginia that has requested copies of engagement agreements and so forth. And so we've briefed this issue about whether panel trustees have any standing to object to a post-petition engagement agreement. And the law's pretty clear that they don't. And it comes back to a very practical concern, and that is that the panel trustee's job is to marshal assets and liquidate them for the benefit of creditors. And so in a traditional prepaid pre-petition engagement agreement, if there's a defect in the engagement or there's an unreasonable fee, presumably, you know, any disgorgement is going to go to the estate, and that's funds that can be distributed to creditors. Mm-hmm. But it's probably immediately clicked in many of your minds that in a post-petition engagement agreement, there's no interest of the estate implicated. There is nothing to recover into the estate. The fees are being paid for over time out of post-petition earnings. And so it's really not part of the trustee's charge. But we don't need to rely on the practical argument, because Rule 2017A and B lay out the roadmap for this. 2017A says any party in interest can challenge payments made to an attorney pre-petition. 2017B says that only the U.S. trustee, the debtor, or the court on its own initiative can challenge payments made to an attorney post-petition. So there's a very clear demarcation that cuts the panel trustee out of the conversation for post-petition payments to an attorney. And we've just briefed that issue, and I'll be out in Virginia on Tuesday arguing that matter for one of our clients, but certainly would have been applicable in the Kentucky situation too. You know, we've had a question raised. There are a number of cases that have been brought by the U.S. trustee over the last couple of years, including in Missouri, Maryland, California, where challenges were made to a lack of disclosure, to unreasonable fees, and so forth, that really follow the same pattern. The one case that was raised in the question that someone raised already had to do with the Casamata case in Kansas City. And all those cases follow the same pattern.
I don't know that Casamata hasn't been resolved, to my knowledge. That's something's happened recently. I haven't checked it maybe in 30 days. But that's the case where the judge did say that bifurcation is allowed in one of her
pretrial opinion
on it. But there's still a question about how he did it and the disclosure.
There have been a number of these kinds of cases, though, you know, involving attorneys that didn't disclose adequately to clients, or they charged an unreasonable fee, or they pretty much uniformly failed to disclose to the court what they were doing. And a lot of them have resulted in settlements. There were several in the Oklahoma City area, an attorney in Maryland that we've talked to quite a bit. There was a stipulation approved in the Ashcraft case in California pretty recently as well.
Yeah, but one thing, I mean, on these cases where these attorneys have entered into these stipulations, I mean, that was all pre-Fresh Start funding. I mean, those all occurred before we were really, you know, out promoting best practices and helping attorneys do things the right way. Now there's a couple challenges now we're dealing with, and we've had great success on these, and look forward to continuing to help attorneys with them. But the ones that Dan just rattled off there, those are all really, they were with a company called BK Billing.
Yeah. And, you know, we're involved on behalf of our clients in a number of things right now where questions have been raised, and we're out making sure that the law is clear on these things. We've got a case pending in Minneapolis right now that will go to an evidentiary hearing probably sometime in March, where we have what seems to be a very receptive judge. He understands and has spoken about the dilemma that is presented by the fact that some folks can't afford to pay attorneys, and attorneys need a way to get paid in order to represent people. We're waiting on Friday, see if the U.S. trustee is going to weigh in with a position in that case, and we'll respond to it in course and then follow through with the hearing there.
But there was a hearing in Texas.
Yeah.
We can talk about that.
So it's not unusual for judges when they first see this practice to sua sponte issue scheduling orders or status conference orders, asking the attorney to come in and explain what's going on. And we had one of those situations arise in Brownsville, Texas earlier, actually in 2019 in the fall. Judge just basically said, debtor's attorney and debtor, please come in and explain this two-contract process. And so we jumped in and filed a bench brief for the attorney who works with us. And we showed up at the hearing, and you know, we proffered the debtor's testimony. She got up and confirmed it and basically said, I think God put certain people in your life at the right times, and this was a blessing in my life. I couldn't have afforded an attorney otherwise. We walked the judge through the disclosures, and the judge said very simply, I have no problem with this practice, and that was the end of it. Mm-hmm. We have a case that's on appeal right now in Oklahoma where an attorney was challenged by the U.S. Trustee's Office, and we got a decision that, at least on the topic of bifurcation, is very favorable. I mean, the first heading in the decision says bifurcation is allowed under the bankruptcy code and cited Hazlett, but then took the attorney to task for various perceived problems with the way in which the bifurcation was carried out. We think the judge got to some wrong conclusions on the how, and so that's pending before the district court in Oklahoma right now on appeal, and we're in the briefing process on that as well.
But still, it's a great opinion in the sense that that district in Oklahoma was viewed as a pretty hostile place for bifurcation. And but this judge made it very clear that you absolutely can bifurcate. You just have to do it the right way.
Yeah. So there is a consistent pattern. I talked about the conversations we have with U.S. trustees' offices. We've seen some of the briefing in some of these cases. And the U.S. Trustee's Office has very kind of consistently now evolved into this position that Hazlett basically announced that bifurcation's okay. We need to focus on the question of how it's actually carried out with clients and disclosure to court and so forth. So
I have to apologize. It looks a couple of people have posted that the audio isn't working great for some people. So we'll try to maybe slow down a little bit, and hopefully you guys will be able to hear everything we're saying.
Yeah, there's a problem sometimes with Zoom that just has to do with the internet carrying the bandwidth, where the audio will get separated from the video. And unfortunately, there's nothing that we can do about that on our end. It's an internet issue. But we will, again, try and be clear and maybe speak a little bit more slowly.
Of course, part of the problem may be that we had over 100 people sign up for this webinar today,
yeah,
which we're excited about.
Yeah, this is actually the most attended webinar that we've done, and I think it's evidence of the fact that there is a lot of interest and curiosity out there about this topic. So we're happy to see folks digging in to learn a little bit more about it.
Yeah. Well, I guess, maybe to summarize the case laws, we've said a little bit already, but it's, there's no question at this point that bifurcation is allowed. It's really just a question of how you do it correctly. And we help attorneys do it correctly. We have great forums, we have great disclosures, we have training that we put attorneys in their offices through. And if for some reason somebody, a trustee or somebody doesn't like it, we'll defend the attorneys and make sure that they don't get themselves in any trouble.
Yeah, and we talk about this all the time that, this litigation is now very much evolving into kind of a predictable course. And, my prediction is that we're going to see far less of these challenges over the next several months because, the U.S. Trustee's Office has seemingly accepted that bifurcation is here and here to stay, and it does address a serious problem. And they're focusing now on the nuts and bolts of how it's done. But in doing that, the bar is becoming better educated as well about how to do it correctly, and we're certainly doing our level best to spread that word as well. And as Matt said, where a question is raised, where a challenge is asserted to this, we offer a defense guarantee and an indemnity as part of our package of services. And I quite literally jump on the plane and fly out and argue these issues in front of judges where the need arises. We take care of the folks who work with us, which maybe is a good segue into talking about exactly what we do, Matt.
Yeah. So when you offer post-petition payment terms to your clients, it raises other issues for attorneys beyond the legal things we've talked about. It raises issues of cash flow, managing the payments, again, making sure you're doing things right with the forms and the like. But we take care of all those things. So we provide a line of credit to the law firm that they can use to cover the liquidity problems that are otherwise created by not getting paid up front and spreading your payments out over 12 months. We handle all of the payment management for the attorneys. So as the debtors make their payments, which we do by normal like debit cards and/or ACHing their bank account, we collect all those payments, and we use the example sometimes where if sometimes people pay weekly, and we don't care if they pay weekly, bi-weekly, monthly, but you just have to pay it in 12 months. But if people are paying weekly and you do 10 cases a month, then by the end of the year you have 120 people paying weekly. That's over 500 payments a month that you're trying to manage. Yeah. So we take care of all that through our technology and our trained staff that we have. We're a very friendly approach to helping keep debtors on track, and when they fall off, figure out ways to get them back on track with their payments.
Yeah, we talk about it in terms of relationship-based payment management. Yeah. So we're acting as your agent, and your name is part of the conversation always, that we're working with the Jones law firm to manage the payments on the Chapter 7 case. We do a welcome call with the debtors when they first sign up and you submit their case for our services. And then we're following up with them to make sure that we're on top of what's going on in their lives. Because these folks, just getting into a bankruptcy doesn't necessarily solve all their problems. Many of them will lose jobs or have health issues and so forth. And so we're sensitive to that and really try and work with them to try and keep them on track. Because one of the other services that we provide is credit reporting. Mm-hmm. And we operate within the rules as positively as possible. In other words, as long as they're communicating with us and we can maintain that communication and a plan for how they're going to get paid, we go out of our way to report them positively or not report them negatively, as the case may be. But that becomes a big part of this for your clients, and a big selling point for a file now, pay later approach to Chapter 7. Because the instant they file their bankruptcy case and they start making payments, they start seeing improvements in their credit score.
Yeah, and we hear from attorneys all across the country that it really is a big factor at those initial consultations of getting people signed up, because people are concerned about their credit. I mean, it has a real impact on their ability to rent an apartment, get a new car, whatever it is they need to do. And when you as their attorney say, not only am I going to file bankruptcy and you get all the benefits of that, I'm also going to help you reestablish your credit right away, because these payments you're going to be making post-petition are going to rebuild your credit.
Yeah. So we certainly have an open book about this too. I mean, we do these webinars. We also provide access to folks to a lot of our articles, the case law summaries, even our forms. And one of the things that we're going to offer is in exchange for you folks spending your time, your valuable time being with us today on this webinar, at the end of this, you'll be provided with a link to a page where you can actually download our forms and get access to all the information we've developed through our nationwide analysis of the case law and working with outside ethics counsel, who's also got a national reputation, to try and make sure that we give folks the correct roadmap to do this legally and ethically.
Yeah, and the good news is we actually just rolled out this week revised pre-petition agreement, post-petition agreement, and disclosures to the court that you need to make. So we've made, as much as they were very good and robust before, they're even better now. Yeah. And the contracts are also more easily understood by the debtors themselves when they go through them.
Yeah, this latest revision really focused on trying to make this as understandable as possible for the debtors. And then the other, collateral benefit for that is that, when and if courts look at it, they see that you've really made an effort to try and make it clear to the debtors so that you're getting that informed consent.
Yep.
All right, so I want to see if we've got some questions teed up. A couple of these are long. Let me just kind of read through.
While you read the top one, I'll read the short one. Is someone's asking if they can get copies of the the contracts and disclosures. And as we just said, absolutely, we have all that available for you.
Yeah. So one of the questions, and I'll just kind of summarize here from Stephen, is that a lot of the debtors in his experience are sort of professional debt avoiders. And so how do we go about trying to get payments from folks who historically have not made payments? But I will tell you, we're very good at it through that relationship-based approach. And in our experience, attorneys who try and collect payments on their own often see 30 or 40% default rates from debtors. But because we've invested in technology and systems and processes and training our people to have a very human-friendly approach, we do very well on collection. People miss payments for various reasons. They've been out sick and their paycheck is short that 2 weeks. And so we have conversations with them about how we keep them on track. As a result, I mean, across the board, we're collecting about 90% of the money, and it's much higher for some attorneys and a little bit lower for others. But we're doing very well in collecting the money.
And just to give you some ideas of what we do. So, the disclosures that you'll use with your clients, we'll tell them all about us. So they're not surprised when they hear from Fresh Start Funding. But as soon as we take over the payments for a client, we have our staff literally call the debtor to just reintroduce us to them, let them know that we're the ones to contact if there's ever any questions. Just start building that relationship so that if they do have a problem, as Dan mentioned, that they miss work for something or an unexpected bill comes up, that they're going to call us and we work out a plan with them on how to keep them on track as best as they can.
Yeah. So part of the question too was, do we take a security interest in anything of the debtors? The answer is no. We're acting as a payment manager for you. So you essentially borrow on your line of credit from us each time you finance a debtor, and then we take over the payment management as your agent from that point on. And another person, Eric, asked what's in it for us, and we charge a percentage of the post-petition fee for all of our services. So you get the whole turnkey portfolio of services and all the ongoing support and education, as well as the defense guarantee and indemnity. And so that's what's in it for us. And then I guess on the payment management side too, we don't sue debtors. We don't refer them to hardcore collection kinds of agencies or anything like that. If they get to the point where we can't get them back on track and they're seriously in default, that case is going to come back to you, and it'll be up to you whether or not you want to take harsher steps with that debtor. But everything we do is relationship based and much more friendly, and consequently quite successful in collecting your dollars.
Yep.
Let's see. Yeah, so Rushi asks, have we had any particular issues with the UST or courts relating to the reasonability of fees and how reasonable this is calculated? And I can tell you that I think that this is one of just a couple of questions that is going to continue to be kind of discussed and potentially litigated in the courts over the next several months. So we do have a couple of cases where that's been raised. And as we talked about, a lot of the U.S. trustees kind of simplistically look at this in terms of a so-called upcharge. You know, if you're charging one amount for a prepaid engagement and another amount for a payment over time, particularly if you're using a third-party company like ours where there's a financing expense to you for doing it, is that reasonable? And the proper view of that, and this is 100% clear under the case law, is that it's the Lodestar approach. Mm-hmm. You take a reasonable market hourly rate times a reasonable amount of time to spend on the tasks, and that provides your baseline value. What we discover when we talk to attorneys is that Chapter 7 practice has been very highly commoditized because of the artificial kind of market that we create around this by insisting that people pay a prepaid fee before they can get relief, and we insist they pay it while they're still struggling with all their financial difficulties. And so the only way that you can differentiate yourself from your competition is by charging a lower prepaid fee. A lot of attorneys who do different types of consumer work, say domestic work or other types of things where they charge an hourly rate, will charge, say, $250 an hour for their services in those other areas. But when you really break down the hourly value of the typical prepaid Chapter 7 charge, a lot of them are working for less than $100 an hour in the Chapter 7 space. And what the Lodestar approach does is it says, tell me what your reasonable hourly rate is. Tell me how much time you typically spend on a Chapter 7. And, you know, if you're at $250 an hour for non-flat fee work and you'd spend, you know, 8 or 10 hours on a Chapter 7 case, you're going to be able to justify a $2,000 to $2,400 fee under those circumstances.
Yeah, and we actually put together a tool too that'll help you figure that out. So we laid out basically a spreadsheet that you can plug in your hourly rates. We put in examples of services typically provided and how much time is spent by the attorney and by staff on the different tasks. You can change it however you like, but it gives you something really good to start with to make sure your fees are reasonable.
Yeah. So what that also involves is a discussion of apples versus oranges too. And so one of the questions asked was, do you take into consideration the risk of non-payment in setting your post-petition fee? And our answer is yes, absolutely. Mm-hmm. If you're collecting a prepaid fee, it's cash up front today. There's no time value of money. There's no risk of non-payment. It's also true that filing a bifurcated case involves a bit more work. I mean, if you're going to do thorough diligence and then still prepare the schedules and statements separately from that in the post-petition engagement, and file different disclosures and so forth, and have a second meeting with their client.
At least one more meeting with the client.
It is a bit more expensive process that will also justify a higher fee. And then we're also big advocates of doing something that seems counterintuitive sometimes at first blush, and that is when you're doing a prepaid engagement and you've got to try to make economic sense of charging the equivalent of $75 an hour or something like that for a Chapter 7 case, the natural thing to do is to carve off as many things as you can from the basic offering that you give to folks. And so, you carve off reaffs and redemptions and adversary proceedings and contested stay relief and all kinds of other things from your basic fee. And where you can charge higher for a pay over time option where they get relief right away, we encourage attorneys to throw back in a lot of those services. They don't come up very often in cases, and when they do, that helps you to justify the higher fee that you're charging, across the board for your Chapter 7 work. But again, it is an apples versus oranges kind of comparison, and it needs to be conducted under the Lodestar approach.
We need to probably wrap this up. We're available for calls. At the end, we'll put up a slide that'll have our phone number. You can call in. We have people here, including us, able to get on the call and answer any other questions. But we've gone past the amount of time we said we would. So.
And I know a number of you are interested in what our specific, financial terms are and so forth for the relationship, and we're happy to talk to you about those things. Candidly, we didn't intend this to be so much of a commercial as a real thorough discussion of bifurcation in the case law. But there are folks here, all day, every day that are happy to talk to you about exactly what we do and what the costs and so forth are of those things. So we're going to go ahead and put up a slide here at the end so that you'll know how to get a hold of us. It'll also have that link to download our forms. You will also get a follow-up email from us that will give you that link as well so that you can, chase those forms down at your leisure. But we want to thank you for spending the time with us today.
Yeah.
We know that this is a topic of hot interest for all of you, and it really does provide an opportunity, as we said from the beginning, to do well by doing good, helping folks out in getting a fresh start where they otherwise wouldn't be able to afford to hire an attorney.
Yeah, and actually one last thing I do want to add though is that we do actively speak around the country. So if any of you have, if your bar or other organization wants to have us come out and speak about bifurcation, we're happy to do so.
Yeah, I just got back from Atlanta, spoke to a group out there, and I'm going to be heading out to Kansas City, a couple of other cities around the country in the next couple of months to speak as well. We'll also be at the NACPA conference in LA. If any of you are attending NACPA in Hollywood, please come see us. Matt and I will both be there on Friday and Saturday, and others will be there for the other couple of days. We'd love to meet you, shake your hand, put a face with some of these names that we've seen today. But again, thank you for your time, and enjoy the rest of your day.
Thank you.